Number 1. Byron David Smith. The Morrison County Sheriff's Office in Little Falls, Minnesota, received a call on the afternoon of November 23, 2012, the day after Thanksgiving, from a resident who had spoken with a neighbor and felt the nature of the conversation warranted official attention. That call initiated a welfare check at a private residence on the outskirts of town that, within hours, became a homicide investigation. Byron David Smith was born on June 11, 1948. Edwards spent the bulk of his professional career working for the United States Department of State as a security engineering officer, a role that involved the design and implementation of security systems at American embassies abroad. By the time he retired, he had accumulated a specific and technical understanding of surveillance, access control, and threat assessment that set him apart from most residents of Little Falls, each a quiet Mississippi River city of approximately 8,000 people, situated roughly 100 miles northwest of Minneapolis. Smith never married and lived alone in a single-family home on a rural property on the outskirts of town. Neighbors described him as a private, self-contained individual. He had no prior criminal history, and within the community he maintained the low profile of a retired professional who kept largely to himself. In the months leading up to Thanksgiving 2012, Smith's property had been subjected to a series of break-ins. Among the items taken across multiple incidents were approximately $4,000 in cash, a collection of coins, a chainsaw, and of particular significance to what followed, 2 firearms removed during a burglary on October 27th. Smith reported only one of the break-ins to the Morrison County Sheriff's Office, though he later stated he believed up to 6 had occurred. Investigators confirmed evidence of 2 burglaries. One on the morning of November 22, 2012, according to the prosecution's account. Smith observed a vehicle he associated with the prior incidents passing near his property. He subsequently drove his own truck to a neighbor's home and parked it there, then returned to his residence through the rear entrance. Once inside, he descended to the basement, where he removed light bulbs from the ceiling fixtures and positioned himself in a chair with 2 firearms, a Ruger Mini 14 rifle and a .22 caliber revolver, set up a digital audio recorder on a shelf, and waited. The recorder ran for more than 6 hours. Exterior surveillance cameras captured 2 teenagers, later identified as 17-year-old Nicholas Brady and 18-year-old Haley Kiefer, cousins who both attended schools in the Little Falls area, approaching and then entering the property. Brady came through a basement window first and descended the stairs. Approximately 10 minutes after the first shots were fired, Kiefer entered through the same point of access and descended to the basement as well. Both were pronounced dead at the scene when deputies arrived the following afternoon. Their bodies were located in the basement, wrapped in tarps. When the Morrison County Sheriff's Office responded to the neighbor's call on November 23rd, Smith led investigators to the basement. The audio recorder he had activated the previous day was recovered and immediately identified as a significant evidentiary item. Upon review, the recording documented the sequence of events in the basement from the moment Brady entered through to the period after Kiefer was shot, including statements made by Smith during and after both encounters, as well as remarks he made in the hours between the 2 deaths. Investigators also examined the exterior surveillance system, in which had recorded Brady and Kiefer approaching and casing the property prior to the break-in. lead investigator Jeremy Luberts of the Morrison County Sheriff's Office coordinated with the Morrison County Attorney's Office as the scope of the evidence became clear. The physical positioning of the bodies, the tarp wrapping, and the 24-hour delay before authorities were notified all factored into the prosecution's theory that the events in the basement were not spontaneous. And to prosecutor Pete Orput later characterized the basement setup, the obscured chair position, the removed bulbs, the staged exterior, and the recording equipment as functionally equivalent to a constructed blind designed to produce a specific outcome. Smith acknowledged to investigators that he had fired more shots than were necessary. He was initially charged with 2 counts of second-degree murder. In April 2013, a grand jury returned an indictment on 2 counts of first-degree premeditated murder. Jury selection for the trial in Morrison County District Court commenced on April 14, 2014, before Judge Douglas Anderson. The prosecution's case was built primarily around the audio recording, which the jury heard in full on multiple occasions across the trial. Orput presented the physical evidence, the staged vehicle, the light bulb removal, the chair positioning, and the stocked supplies, as documentation of a deliberate plan formed before Brady and Kiefer entered the property. Defense attorney Stephen Meshbisher argued that Smith had been a victim of repeated burglaries, that his fear was genuine, and that his actions were a response to what he experienced as an ongoing and unaddressed threat to his safety. The defense requested that the court admit records related to Brady and Kiefer's prior involvement in burglaries, including a separate incident that occurred the night before their deaths. Judge Anderson excluded that evidence, ruling that Smith had not confirmed knowledge of their identities before November 22nd. Smith did not take the stand. After approximately 3 hours of deliberation, the jury returned verdicts of guilty on all 4 counts: 2 counts of first-degree premeditated murder and 2 counts of second-degree murder. Byron David Smith was immediately sentenced to 2 concurrent terms of life in prison without the possibility of parole. He has pursued multiple rounds of appeal, including challenges to the Minnesota Supreme Court, the 8th Circuit Court of Appeals, and a petition to the United States Supreme Court. All appeals were denied, with the Supreme Court declining to hear the case in March 2021. Smith remains incarcerated at the Minnesota Correctional Facility in Oak Park Heights. It's where he continues to serve his sentence. Number 2. Craig Stephen Hicks. Following the shooting at Finley Forest Condominiums on Summerwalk Circle on the evening of February 10, 2015, Craig Stephen Hicks drove away from the complex and spent approximately an hour at Jordan Lake before driving to Pittsburgh, where he surrendered to deputies at the Chatham County Sheriff's Office. He was in possession of a .357 caliber handgun at the time of his arrival. In the investigation that followed would span more than 4 years before it reached a courtroom. Craig Stephen Hicks was 46 years old at the time of the shooting, a former car parts salesman who had relocated to Chapel Hill from Bethalto, Illinois, in 2005. At the time of the incident, he was enrolled at Durham Technical Community College, studying toward a paralegal qualification, and was described by the institution as an academically capable student. In his personal life, had been marked by instability. He had been married twice, one marriage lasting only 5 months, and those who knew him in a domestic context described what was characterized in later court proceedings as a pattern of controlled, calculated behavior. He maintained a substantial personal firearms collection. Investigators recovered more than a dozen weapons from his residence, including 2 fully loaded handguns, an AR-15 Bushmaster rifle, 2 shotguns, and 5 additional long guns. Neighbors at the Finley Forest complex had reported concerns about his behavior over an extended period, characterizing him as habitually confrontational, particularly toward residents he perceived as encroaching on shared parking allocations. Multiple accounts described him approaching neighbors while visibly armed. The 3 individuals connected to the address at the center of the investigation were 23-year-old Dia Shadi Barakat, as a second-year student at the University of North Carolina School of Dentistry. His wife, 21-year-old Yusor Muhammad Abu Salha, a recent graduate of North Carolina State University, who had been accepted into the same dental program, and her 19-year-old sister, Razan Mohammed Abu Salha, an NCSU student majoring in architecture and environmental design. Barakat and Yusor had been married less than 2 months. The 3 were together at the couple's condominium on the evening of February 10th, sharing a meal. Evidence later presented at sentencing established that in the weeks prior to February 10th, Barakat had been taking steps to document Hicks's behavior in preparation for a restraining order application. On that evening, when a knock came at the door, Barakat activated the video recording function on his mobile phone before answering. The 36-second recording captured the exchange at the door, including Hicks raising a complaint about parking allocations, and the moment Hicks drew his handgun and opened fire. Barakat was struck multiple times. Both Abu Salha sisters were also shot. All 3 died at the scene. Investigators recovered 8 shell casings in the living room and an additional round elsewhere inside the residence. Ballistic analysis confirmed the handgun Hicks surrendered matched the casings recovered. The Chapel Hill Police Department's initial public statement characterized the shooting as potentially stemming from a dispute over parking. That framing was immediately and vigorously disputed by the victims' families, who maintained from the outset that Hicks had specifically targeted their relatives on the basis of their Muslim faith and their visible religious identity. Both women wore hijab. Your prosecutors at sentencing would later present evidence that Hicks's approach to confrontation differed systematically depending on the background of the neighbor involved. With white neighbors, disputes remained verbal. With non-white and minority neighbors, he introduced the presence of a firearm. Witnesses testified to specific prior incidents matching that pattern. A social psychologist from Tufts University was retained as an expert to address the question of intergroup bias, concluding that the available evidence was consistent with the victims' identities, playing a role in how Hicks perceived and responded to them. The FBI conducted a parallel preliminary inquiry into potential federal hate crime violations and referred findings to the U.S. Attorney's Office in Greensboro. Prosecutors ultimately determined the evidentiary threshold for a federal hate crime charge could not be met, a conclusion that generated significant public criticism. Hicks was indicted by a Durham County grand jury on February 16, 2015, on 3 counts of first-degree murder and 1 count of discharging a firearm into an occupied dwelling. The case underwent prolonged pre-trial proceedings over more than 4 years. Durham County District Attorney Roger Eccles initially announced in March 2015 that the state intended to seek the death penalty. Yet that position was reversed in April 2019 when incoming District Attorney Satana Debary withdrew the death penalty designation. stating that the case had remained unresolved for too long and that concluding it efficiently was the priority. On June 12, 2019, Hicks appeared before Superior Court Judge Orlando Hudson in a Durham courtroom, packed with the victims' families and supporters. He entered guilty pleas to all 3 counts of first-degree murder. In a significant procedural development, the prosecutors played Barakat's mobile phone recording in open court for the first time. The footage showed Hicks at the door making the parking complaint, the exchange that followed, and the moment he drew and fired. Multiple family members in the front row were visibly overcome. One fainted. The recording directly contradicted Hicks's post-arrest account to investigators, in which he had claimed Barakat had been aggressive and had moved toward him. In expert testimony introduced at the sentencing hearing, confirmed the video showed no such conduct. Judge Hudson sentenced Hicks to 3 consecutive terms of life imprisonment without the possibility of parole, plus a consecutive sentence of between 64 and 89 months for the firearms discharge charge. Hicks remains incarcerated in the North Carolina State Prison System. When the victim's family subsequently stated publicly that the cell phone recording had allowed them to counter the parking dispute characterization that had defined early media coverage of the case, and to establish a factual record of what occurred at that door on the evening of February 10, 2015. Number 3. Marcus Hendrick Karma. Then 3 witnesses independently approached the Missoula County Attorney's Office in the weeks following a shooting at a residential property on Deer Canyon Court in Grant Creek, Montana. Each reported hearing the same individual make statements about waiting up at night with the intention of shooting someone who entered his garage. Those accounts, combined with the physical evidence recovered from the scene, shifted the investigation from a self-defense inquiry into a deliberate homicide case. Marcus Hendrick Karma was 29 years old at the time of the events in April 2014, residing in a single-family home in Grant Creek, a quiet residential neighborhood in the foothills outside Missoula. He worked as a firefighter and lived at the property with his partner, Janelle Flager, and their infant son. Karma had no significant prior criminal history that factored into the case. The neighbors who later spoke to investigators and the press described a man whose temperament had become increasingly volatile in the period preceding the incident. Accounts included confrontations with other drivers on public roads and what multiple sources characterized as erratic or aggressive behavior in day-to-day interactions. Karma's own statements to police confirmed the general timeline of events without dispute. But the framing of those events, whether they constituted lawful self-defense or a premeditated act, became the central issue of the entire proceeding. The property on Deer Canyon Court had been burglarized on at least 2 separate occasions in the weeks before April 27, 2014. Items taken included marijuana, and Karma had reported the incidents to local authorities. Following those break-ins, the Karma installed motion sensors in the attached garage and positioned a surveillance system capable of alerting him to movement inside. According to Flager's initial statements to investigators, she and Karma had deliberately left the garage door partially open on multiple nights in the period leading up to the shooting, a detail that prosecutors would later characterize as central to the case. Shortly after midnight on April 27th, the motion sensors triggered an alert. Karma retrieved a 12-gauge pump-action shotgun and moved to the garage entrance. Without activating any light source, Without identifying the person inside and without issuing any verbal warning, he fired 4 rounds into the darkened garage. Diren Dady, a 17-year-old exchange student from Hamburg, Germany, enrolled at Missoula's Big Sky High School, was struck twice, once in the arm and once in the head. He was transported by ambulance to a nearby hospital, where he died of his injuries approximately 30 minutes after the shooting. He had approximately 6 weeks remaining in his exchange program. He was unarmed. The Missoula County Sheriff's Office and the County Attorney's Office began building their case around 2 parallel lines of evidence. The first was physical. The positioning of Karma when he fired was the trajectory of the 4 rounds, including a pause investigators noted between the 3rd and 4th shots, and blood spatter analysis conducted by Detective Guy Baker, whose findings corroborated the prosecution's reconstruction of events inside the garage. The second line was testimonial. 3 separate witnesses, including a stylist at a local hair salon, a neighbor, and another individual known to Karma, came forward and reported that he had made statements in the days and weeks before April 27th to the effect that he had been waiting up at night and intended to shoot anyone who came into the garage. Flogger's own account to investigators confirmed the practice of leaving the garage open at night. Prosecutors Andrew Paul and Jason Marks developed an argument that the physical setup, sensors, open door, a loaded weapon kept accessible, reflected not a reactive defensive posture, but a deliberate effort to draw an intruder onto the property. The case also attracted diplomatic attention. German authorities in Hamburg opened their own inquiry as required under German law, and the German government formally raised the matter with U.S. counterparts. Karma's trial in Missoula County District Court before Judge Ed McLean opened in December 2014, and the prosecution presented the case as deliberate homicide under Montana law, a charge broadly equivalent to first-degree murder in other jurisdictions. Prosecutors argued that the combination of the open garage, the motion sensors, the prior witness statements, and the decision to fire 4 shots blindly into a darkened space without issuing a warning collectively demonstrated deliberate action rather than a defensive response to an immediate threat. The defense, led by attorneys Brian Smith and Paul Ryan, argued that Karma was a homeowner acting under genuine fear for the safety of himself, his partner, and his infant child, that Montana's Castle Doctrine law permitted the use of deadly force when a reasonable person believed their household to be at risk, and that Karma had no way of knowing whether the person in the garage was armed. The jury was instructed on the applicable self-defense and Castle Doctrine statutes. After deliberation, they returned a verdict of guilty on the charge of deliberate homicide on December 17, 2014. The courtroom erupted in audible reaction when the verdict was announced. Dee Dee's parents, who had traveled from Hamburg to attend the trial, were present. Marcus Karma was sentenced on February 12, 2015, to 70 years in Montana State Prison, with no possibility of parole for the first 20 years. At sentencing, Judge McLean addressed Karma directly, stating that his actions amounted to hunting rather than home defense, and characterizing the evidence as reflecting a disposition of generalized anger. Karma appealed to the Montana Supreme Court in late 2015. That court upheld the conviction in February 2017, finding no reversible error in the trial proceedings. A subsequent petition for post-conviction relief, based on ineffective assistance of counsel, was denied by Judge McLean in July 2019. The United States Supreme Court declined to hear the case. Karma remains incarcerated in the Montana State Prison System, eligible for a parole hearing after serving 20 years of his sentence. Number 4. Michael David Dunn. The Jacksonville Sheriff's Office opened a homicide investigation on the morning of November 24th, 2012, after reviewing security footage from a Gate Petroleum convenience store on Southside Boulevard. Footage that documented the entirety of an exchange in the parking lot the previous evening and directly contradicted the account provided by the individual who had already left the scene. Michael David Dunn was 45 years old at the time of the incident, a software developer living in Satellite Beach, Florida, approximately 170 miles south of Jacksonville in an oceanfront town home in Brevard County. By professional background and social presentation, Dunn occupied the position of a mid-career technical professional, a man his own attorney would later describe as non-confrontational and law-abiding. He held a valid Florida concealed weapons permit. On the evening of November 23, 2012, he and his fiancée, Rhonda Ruhr, were in the Jacksonville area to attend his son's wedding in Orange Park. The couple had left the reception early to return to their hotel and check on their puppy. Dunn was dressed in a suit and tie. By every visible external measure that evening, his behavior up to a specific moment at a gas station parking lot conformed entirely to that of someone completing an unremarkable end to a family occasion. At approximately 7:30 p.m., Dunn pulled his black Volkswagen Jetta into the Gate Petroleum station at the corner of Southside Boulevard and Bay Meadows Road. He parked in the space immediately adjacent to a red Dodge Durango SUV occupied by 4 teenagers: Tommy Storns, Leland Brunson, Tevin Thompson, and 17-year-old Jordan Russell Davis, who had stopped to purchase gum and cigarettes. The SUV's stereo was playing music at high volume. Storns had gone inside the store. Dunn addressed the 3 teenagers remaining in the vehicle and asked them to turn the music down. The request was initially complied with, but Davis, seated in the rear, objected to the request, and the volume was raised again. An exchange of words followed. Dunn reached into the glove compartment of the Jetta and retrieved his handgun. He fired 3 separate volleys into the Durango, 10 rounds in total. As the Durango reversed away from the pumps, Dunn opened his car door, stepped out, and continued firing from a standing position as the vehicle moved. 3 rounds struck Davis, penetrating his liver, a lung, and his aorta. Ruhr returned from inside the store, and Dunn drove to their hotel approximately 3 miles away. The couple ordered pizza, consumed alcohol, and Dunn did not contact law enforcement. Storns drove the Durango to a nearby parking lot and discovered Davis struggling to breathe. Davis died before emergency services arrived. No firearm was located in the SUV, in the surrounding parking area, or anywhere in the vicinity of the scene. The morning after the shooting, Ruhr saw a news broadcast confirming that a teenager had died at the gas station the prior evening. The couple drove back to their home in Brevard County without contacting Jacksonville authorities. A tip from a witness who had observed the license plate led investigators to Dunn's address, and he was taken into custody in Satellite Beach the following day, November 24th. During the arrest, he was found in possession of the .380 caliber handgun used in the shooting. The investigators processed the Gate Petroleum surveillance footage, which provided a clear visual record of the encounter, the firing sequence, and Dunn's exit from his vehicle while continuing to discharge rounds at the moving SUV. A search of Dunn's communications, specifically letters written from jail in the months following his arrest, produced written statements containing racial language directed at the teenagers involved and expressions of justification for his conduct. Iruer agreed to testify for the prosecution and disclosed that Dunn had characterized the music as what she described in court as thug music before she had exited the vehicle that evening. The absence of any weapon in or near the Durango, combined with those written communications, became foundational to the prosecution's argument that Dunn's stated belief in a threat was not the operative factor in his decision to fire. Dunn was indicted by a grand jury on December 13, 2013, on charges including first-degree murder and 3 counts of attempted second-degree murder. His first trial commenced in Jacksonville's Duval County Circuit Court in February 2014. Ruhr testified for the prosecution and confirmed that Dunn had made no mention of seeing a weapon when he described the encounter to her that night. She also confirmed he had not called 911. And Dunn took the stand and testified that he had seen what appeared to be a gun barrel extending from the rear window of the Durango, and that his actions were a response to that perceived threat. No such weapon was ever found. The prosecution countered that the continued firing at a retreating vehicle, including the tactical stance Dunn adopted outside his car, was inconsistent with any reasonable interpretation of defensive action. The jury convicted Dunn on 3 counts of attempted second-degree murder and 1 count of firing into an occupied vehicle but deadlocked on the first-degree murder charge. A mistrial was declared on that count. Sentencing on the 4 convictions was deferred pending retrial. A second trial on the murder charge began September 22, 2014. On October 1, 2014, the jury returned a verdict of guilty on first-degree murder. Michael David Dunn was sentenced to life in prison without the possibility of parole, plus an additional 90 years for the remaining counts. The combined structure of the sentence was noted by the court as effectively precluding any possibility of release, regardless of appeal outcomes. Dunn's conviction was affirmed by Florida's First District Court of Appeal in September 2016. The Florida Supreme Court declined to take up a subsequent appeal in June 2020. Dunn remains incarcerated in the Florida state prison system, serving a sentence from which no legal pathway to release currently exists. Jordan Davis's mother, Lucia McBath, later ran for and won a seat in the United States House of Representatives from Georgia's 6th Congressional District, citing the circumstances of her son's death as the defining reason for entering public service. Number 5. Hector Arturo Campos. Were Harris County authorities responding to a shooting call on the 3400 block of Morning Dove in Spring, Texas, on the afternoon of January 24, 2017, arrived to find a neighbor from across the street already on scene, holding the individual suspected of firing the shot at gunpoint. A woman was down in the front yard. A small dog was nearby. The scene had been effectively contained before law enforcement reached it, with the suspected shooter unable to leave the property. Hector Arturo Campos was in his early 40s at the time of the shooting and had resided on Morning Dove in Spring, a residential suburb north of Houston in Harris County, for approximately 10 years. By the accounts of those who knew him in the neighborhood, he had not always been a source of conflict on the street. In the earlier years of his time there, Relations with at least some neighbors had been cordial. He was married with an infant daughter and kept largely to himself. As time passed, however, a picture emerged among people who lived nearby of someone whose behavior within his household raised concerns, with neighbors later testifying that his conduct toward his wife was controlling and that she had limited freedom of movement. By mid-2016, those internal tensions had begun to manifest externally, generating friction specifically with the woman who lived next door, who had become aware of the conditions inside his home. And the documented origin of the dispute between Campos and 53-year-old Anna Weed, a wife, mother, and grandmother who had lived next door to him for the same decade, traced to June 2016. Campos had arranged a family trip to Mexico for himself, his wife, and their infant daughter. He subsequently changed his mind and attempted to cancel the trip. His wife proceeded with the journey regardless, and Weed drove her and the infant to the airport to facilitate their departure. De Campos filed for divorce in the months that followed. During the period between June 2016 and January 2017, the dynamic between Campos and Weed deteriorated. Neighbors documented confrontations and reported that police had been called to the street at least once to manage a verbal dispute between them, with witnesses describing the exchanges as escalating in hostility over time. On the morning of January 24th, 2017, Campos was in his driveway cleaning and detailing a truck. Weed was in her front yard with her small dog. A confrontation developed during which Campos demanded information about the whereabouts of his estranged wife and daughter. In the course of the exchange, Weed's dog moved toward Campos, and he attempted to kick the animal. Weed moved onto his property to retrieve the dog and then stepped back toward her own yard. Campos crossed from his driveway to the property line and discharged a single handgun round. Weed was struck once in the chest and fell in her front yard. She was holding a length of clear packing tape. She had been wrapping a gift for her grandson inside the house before the confrontation began. She died at the scene. The neighbor who witnessed the shooting from across the street retrieved a firearm and held Campos in place until responding officers arrived. He did not flee. Responding investigators recovered the handgun, documented the scene, and conducted an initial interview with Campos, who immediately offered a self-defense account. He told investigators that Weed had physically pushed him and then made a motion suggesting she intended to use the packing tape as a weapon against him. Investigators noted that Weed had been standing on or near the property line at the time of the shot, and that the single round had struck her in the chest. The physical evidence, her position at the moment she was shot, the tape in her hand, the absence of any independent corroboration of an assault by Weed, was inconsistent with the account Campos provided. Detectives also established the history of the feud and its specific origin in the events of June 2016, providing context for the prosecution's theory of motive. Campos was charged with murder. He was released on bond, but a district judge later increased the bond to $175,000 following the charge. In May 2022, more than 5 years after Weed's death, a Harris County civil jury returned a $70 million wrongful death verdict against Campos in a suit brought by Weed's family. The criminal trial followed weeks later. The criminal trial took place in Harris County District Court before Judge Taiva Bell in late June 2022, with prosecutors Christopher Condon and Ryan Trask presenting the case for the state. Yet the prosecution's central argument was that the shooting was not a spontaneous defensive act, but the culmination of a sustained grievance rooted in Campos's belief that weed had enabled his wife's departure and the breakdown of his marriage. Witness testimony established the timeline of the feud and documented the prior confrontations on the street. The physical evidence from the scene was placed before the jury alongside Campos's account, and the defense argued self-defense and also raised the claim of sudden passion, a legal standard under Texas law that, if accepted, could reduce the severity of the conviction. Prosecutors countered that the deliberate movement by Campos from his driveway across the property line, handgun in hand, did not reflect a sudden reaction, but a considered act. The jury rejected both the self-defense claim and the sudden passion argument, convicting Campos of murder. During the sentencing phase, Weed's sister addressed the court in a victim impact statement, followed by other family members who described the 5.5-year wait from the day of the shooting to the criminal verdict. Hector Arturo Campos was sentenced to 45 years in state prison. Given the length of the sentence and his age at the time of conviction, the term represents a functional life sentence. He remains incarcerated in the Texas state prison system, and no successful appeal has altered the conviction or the sentence. The civil judgment of $70 million entered against him in May 2022 remains on record. Number 6. Neil Zumberg. New Brighton Police Department dispatch logs for the 2,500 block of Knollwood Drive in Ramsey County, Minnesota document a call received at approximately 8:30 p.m. on May 5, 2014. A report of shots fired and a person down in front of a residential property. Responding officers noted upon arrival and that a neighbor from an adjacent property had already detained the individual believed to have discharged the firearm. Todd Stevens, 46, was pronounced dead at the scene. His partner, Jennifer Damerow Cleven, was transported by ambulance with a gunshot wound to the abdomen. Neil C. Zumberg was 57 years old at the time of the shooting and had resided at a single-family home on Knollwood Drive in New Brighton, a suburb located north of St. Paul, since 1997. And he was married to Paula Zumberg, and the couple had 3 children together. By occupational record, he was not a public figure and lived what appeared outwardly to be an ordinary suburban life. Within the neighborhood, however, the picture that emerged over years of police interaction was considerably more complicated. Zumberger had developed a fixed belief that he had contracted Lyme disease, a tick-borne illness, and attributed that condition directly to the deer population that gathered near his property. Deer, he maintained, were drawn specifically to his neighbor's yard across the street by a wildlife feeding station they maintained. Over the years that followed his move to the street, the belief calcified into a driving grievance that shaped an escalating pattern of behavior directed at the couple who lived directly opposite him. Yet the feud between Zumberg and 46-year-old Todd Stevens and his partner Jennifer Damerow Cleven had been documented by New Brighton police across more than a decade. Officers had been called to the block on multiple occasions for disputes, and Damerow Cleven had at one point obtained a harassment restraining order against Zumberg through the courts. Despite the legal order, the conflict continued. Dead animals were found on Stevens and Damerow Cleven's property on more than one occasion. Like in the wildlife feeder they maintained, disappeared. In the week immediately preceding May 5, 2014, the situation escalated sharply. Damerow, Cleven, and Stevens encountered Zumberge's adult son, Jacob, at a local VFW hall in Spring Lake Park. Jacob Zumberge made threatening statements and physically shoved Stevens before leaving. The couple reported the incident, and an arrest warrant was issued for Jacob. On the evening of May 5th, when Damerow Cleven spotted Jacob Zumberge at a restaurant in New Brighton and notified police, who arrived and took him into custody. She then drove home, arriving around 8:30 p.m. Paula Zumberge, informed of her son's arrest, came out of the house and confronted Damerow Cleven verbally across the street. Stevens came out of the house and stood near the front door. From the side of the Zumberge residence, Neil Zumberge emerged. While he had retrieved a 12-gauge Browning semi-automatic shotgun from inside the house, where it had been kept accessible near a couch since the VFW incident, descended to the basement and exited through an egress window. He fired from a distance investigators established at approximately 145 feet. Stevens was struck in the head, torso, and spinal column and died almost immediately. Damerow Cleven was struck by shotgun pellets and injured. No weapon of any kind was found on Stevens, and the object on his belt, which witnesses later said Zumberge claimed he mistook for a firearm, was identified as a mobile phone holster. Ramsey County investigators conducted an initial interview with Zumberge the same evening. His account to police was that he had acted to protect his wife, believing Stevens was reaching for a gun. He did not mention seeing Stevens issue a verbal threat during that initial interview or in his subsequent 911 call, an omission prosecutors would later characterize as significant. The physical evidence, the exit through the basement egress window, the distance to Stevens, and the multiple rounds fired, formed the foundation of a premeditation argument. Ballistic and forensic analysis documented the firing sequence. A grand jury indicted Zumberge on charges of first-degree premeditated murder, second-degree murder, first-degree attempted murder, and second-degree attempted murder. His wife, Paula Zumberge, each was separately charged with aiding and abetting. She was tried before a judge in August 2014 and acquitted. The court found the state had not established beyond a reasonable doubt that she had encouraged the shooting, despite testimony from Damerow Cleven to the contrary. Neil Zumberge's criminal trial was scheduled and reset multiple times before opening in Ramsey County District Court in August 2015. At trial, prosecutor Anna Christie presented the egress window exit. It's the shotgun's prior positioning in the living room and the distance from which Zumberge fired as evidence of deliberate preparation rather than a spontaneous response to a perceived threat. She highlighted the absence of any mention of a verbal threat from Stevens in either the 911 call or the initial police interview, and introduced testimony from Paula Zumberge, who stated she hadn't been threatened and hadn't feared for her safety during the exchange with Damerow Cleven. The defense, led by attorney William Orth, argued that Zumberge was a man whose years of genuine conflict with Stevens had placed him in a state of reasonable fear, and that his decision to arm himself was precautionary rather than predatory. Zumberge took the stand and testified that he could read lips, having grown up with a deaf sibling, and that he had seen Stevens make a threatening statement before reaching toward his belt. The jury deliberated for 2 hours before returning verdicts of guilty on all 4 counts. Neil Zumberge was sentenced on September 15, 2015, by Ramsey County District Judge Margaret Marinan to life in prison without the possibility of parole for the first-degree murder conviction, plus a consecutive 15-year term for the attempted murder charge. At sentencing, Zumberg acknowledged that his trial testimony hadn't been fully truthful. Usen offered a revised account of the events of May 5th that more closely aligned with the prosecution's reconstruction. Judge Marinan acknowledged his apparent remorse, but confirmed that the physical evidence fully supported the premeditation verdict. The Zumberg family sold their home on Knollwood Drive to fund Neal's legal defense. He remains incarcerated in the Minnesota State Prison System. Number 7. Theodore Paul Wafer. The Dearborn Heights Police Department received a 911 call at approximately 4:42 a.m. on November 2, 2013, from a male caller who reported that he had shot someone on his front porch. Responding officers arrived at a residential address on West Outer Drive to find a 19-year-old woman deceased, struck by a single shotgun blast to the face. The caller was present at the scene. No weapon of any kind was found on or near the victim. Yet the Dearborn Heights Department did not immediately make an arrest. Wayne County Prosecutor Kim Worthy's office subsequently dispatched its own investigators, a step that proved consequential to what followed. Theodore Paul Wafer was 54 years old at the time of the shooting, a maintenance and transportation worker employed at Detroit Metropolitan Airport, where he held a high-level security clearance. He had attended Northern Michigan University briefly and lived alone in a single-family home in Dearborn Heights, a suburb directly adjacent to Detroit. Those who knew him through work described a man who performed his duties reliably over a period of roughly a decade. His home, according to later court testimony, had been the subject of what he believed was minor targeted vandalism, including an incident involving paintballs striking his vehicle in the period preceding November 2013. And then he kept a Mossberg 512-gauge shotgun loaded and accessible inside the residence. He was white. Renisha McBride, the 19-year-old who arrived at his door that morning, was black. That demographic fact became a defining element of the public and legal conversation that followed. In the early hours of November 2, 2013, Renisha McBride had been socializing at a residence in the Southfield area. Toxicology results from the subsequent autopsy documented a blood alcohol concentration of 0.22, nearly 3 times the legal driving threshold, and the presence of marijuana. Shortly before 1 a.m., she crashed her vehicle at the intersection of Bromell and Majestic on Detroit's west side, striking a parked car. A nearby resident heard the collision and observed McBride outside the vehicle, visibly disoriented and with a wound to her hand. McBride did not remain at the crash scene. Her precise movements during the 3.5 hours that followed were never fully established. At approximately 4:30 a.m., she arrived at the front porch of Wafer's home on West Outer Drive, approximately a mile from where the crash had occurred. She knocked on the door. Accounts variously described the sound as knocking or more forceful pounding. Wafer, woken by the noise, retrieved his shotgun. He came to the front door. He did not call 911. Yet he opened the inner door and fired a single round through the locked screen door. McBride was struck in the face at close range. Prosecution forensic experts would later establish the distance at approximately 3 feet, and died on the porch. She was unarmed and carried no tools, consistent with forced entry. Wafer's initial statement to responding officers was that the discharge had been accidental. In the days following the shooting, where the absence of any arrest generated significant public attention and drew immediate comparisons in national media coverage to the February 2012 shooting of Trayvon Martin in Florida. Wayne County Prosecutor Worthy's office took over the investigative direction from the Dearborn Heights Department and announced charges on November 15, 2013. Second-degree murder, statutory manslaughter, and felony firearm. Investigators examined the physical condition of the screen door, which had been partially dislodged when officers arrived. The prosecution's position was that the damage occurred after Wafer fired, not before. A defense expert offered the alternative interpretation that the screen door's condition reflected McBride's actions prior to the shot. Forensic analysis confirmed no accidental discharge mechanism consistent with Wafer's initial account. The weapon required deliberate trigger pressure. In the absence of a prior 911 call, despite Wafer's stated belief that he was facing an intruder, was identified by the prosecution as a central inconsistency in his self-defense claim. The trial opened in Wayne County Circuit Court before Judge Dana Hathaway on July 21, 2014. Wafer testified in his own defense, stating that he had been genuinely frightened, that he had been unable to locate his phone to call 911, and that he had chosen to confront what he believed was a threat rather than retreat further into the house. He acknowledged firing the shot deliberately, abandoning the accidental discharge account he had initially provided to police. Lead prosecutor Patrick Muscat argued that Wafer had had multiple options available to him, including remaining behind a locked door or locating his phone, and that the choice to open the door and fire reflected aggression rather than reasonable fear. The prosecution characterized Wafer as an angry, increasingly paranoid man whose decision-making that morning was not consistent with any objective standard of imminent threat. The jury, 7 women and 5 men, deliberated for under 10 hours across 2 days before returning guilty verdicts on all 3 counts on August 7, 2014. Wafer was sentenced on September 3, 2014, to 17 to 32 years in prison. In February 2022, whereas the Michigan Supreme Court vacated the manslaughter conviction on double jeopardy grounds, finding that convicting a defendant of both second-degree murder and statutory manslaughter for a single act violated constitutional protections. Wafer was resentenced by Judge Hathaway on June 22, 2022, to 15 to 30 years for the murder conviction, plus 2 years consecutive for the felony firearm charge. The functional sentence remained equivalent to the original. Having served approximately 9 years at the time of resentencing, Wafer became eligible for parole consideration in 2031. He remains incarcerated in the Michigan State Prison System. Number 8. Andrew Daniel Lester. Kansas City Police Department records from the evening of April 13, 2023, document a dispatch to a residential address on NE 115th Street in the Northland area of the city, following reports of a teenager found injured in the street. Officers arrived to find a 16-year-old male with 2 gunshot wounds, one to the head and one to the right arm. He had knocked on the doors of 3 neighboring properties seeking help before being located. The registered occupant of the address from which the shots had been fired was still inside the residence. Andrew Daniel Lester was born on October 21, 1938, and was 84 years old at the time of the shooting. A former military airman who served during the Vietnam War era, he subsequently built a civilian career as an aircraft mechanic, spending years working for America West Airlines before retiring. He had lived in Virginia before relocating to the Kansas City area, and at the time of April 2023 was residing alone in a single-family home in the Northland District. By the accounts of those who knew him, he was a private, self-contained individual in declining health. He had undergone heart surgery and a knee replacement in the period preceding the shooting, worked and lived without close daily social contact. He was white. The teenager who arrived at his door that evening was black. Ralph Yarl was 16 years old, an academically accomplished student at Staley High School in Kansas City, and a multi-instrumentalist who had been named to the Missouri All-State Band. On the evening of April 13th, his mother had asked him to collect his younger twin brothers from a play date. The correct address was on the 1100 block of Northeast 115th Terrace. Yarl, without his phone and relying on memory, arrived instead at a home on NE 115th Street, less than a block away. He rang the doorbell and waited. According to his subsequent account, the inner door opened, and he reached toward the storm door, assuming it belonged to his brother's friend's parents. Lester fired a .32 caliber Smith & Wesson revolver through the glass of the front door. The first round struck Yarl above his left eye. A second round struck him in the upper right arm. Yarl fell to the ground outside the door. Lester did not render assistance or call emergency services. Yarl got up and ran, seeking help at neighboring homes. A neighbor eventually called 911. Yarl was transported to hospital and released 3 days later. Medical documentation confirmed he had sustained a traumatic brain injury as a result of the head wound. In the 911 call Lester made after the shooting, he was recorded saying that someone had rung his doorbell and that he had fired because he feared the person wanted to enter his home. The Clay County Prosecutor's Office took on the case, and Zachary Thompson was the lead prosecutor. Lester was not arrested immediately. He turned himself in to authorities several days after the shooting, on April 17th. The delay generated significant public attention, and civil rights attorney Benjamin Crump was retained by Yarl's family, who called for swift legal action. Thompson charged Lester with first-degree assault and armed criminal action, charges that together carried a sentencing exposure of 10 years to life in prison. Thompson publicly stated that investigators identified a racial component to the shooting. The incident was widely covered in national and international media and drew public statements from President Biden, former First Lady Michelle Obama, and numerous other public figures. It became the focal point of a broader national discussion after 3 other unrelated shootings of individuals at wrong addresses or locations were reported across the United States within the same week. Investigators established that Yarl had provided no threatening conduct, had no weapon, and had been standing at the door of a stranger's home under a straightforward navigational error. Lester told officers he could not physically defend himself against someone of Yarl's build, and that he had acted out of fear. Legal proceedings extended over nearly 2 years. Lester initially pleaded not guilty and was released on a $200,000 bond. His defense attorney, Steve Salmon, argued that Lester's advanced age, deteriorating physical condition, and declining mental capacity were relevant factors, and the initial October 2024 trial date was postponed after a judge ordered a psychiatric evaluation. In November 2024, Lester was found mentally competent to stand trial, and a new date of February 18, 2025 was set. A civil lawsuit brought by Jarl's mother was settled for $100,000 in the interim. 4 days before the rescheduled trial was to begin, on February 14, 2025, Lester appeared in Clay County Court in a wheelchair and pleaded guilty to a single count of second-degree assault, a Class D felony, carrying a maximum of 7 years in prison. The original charges were dropped as part of the plea, and Thompson stated publicly that the plea was reached in consultation with Jarl and his family, and that the prosecution would seek a 5-year custodial sentence at the March 7th sentencing hearing. The sentencing hearing never took place. On February 19th, 2025, 5 days after entering his guilty plea, Andrew Lester died from medical complications at the age of 86. Because his death occurred before the sentencing was formally concluded, he was never legally classified as a felon under Missouri law. Clay County prosecutors moved to dismiss the case. The conviction, entered only days earlier, was extinguished by his death before it could be formalized. Jarl's family issued a statement noting that his death did not constitute justice, and that the 2-year delay before the case reached resolution had itself been a prolonged harm. Ralph Jarl is currently enrolled at Texas A&M University. Number 9. Austin David Thompson. Emergency calls to Raleigh Police Department dispatch beginning shortly after 5 p.m. on October 13, 2022, reported multiple gunshots and a person down in the Hedingham neighborhood, a residential subdivision in the northeast of the city. Within minutes, it became clear the reports were not describing a single incident. Officers, responding to separate locations across the neighborhood and along the adjacent Neuse River Greenway Trail, found multiple victims. The shooting was still active, and the individual responsible hadn't yet been located. Austin David Thompson was 15 years old at the time of the events of October 13, 2022. He lived with his family in the Hedingham subdivision, which had been his neighborhood for the entirety of his life. His parents later testified at his sentencing hearing that he had been, by every outward measure available to them, an unremarkable teenager, academically functional, socially untroubling, years with no documented history of violence or behavioral intervention. There were no prior contacts with law enforcement, no incidents flagged by school authorities, and no formal therapeutic history. His father described him in court as a normal and happy child who showed no signs of what was to come. Thompson was enrolled in school, had friends in the neighborhood, and had no public record that would have distinguished him from any other 15-year-old in the community. His age, at the time of the crimes, meant he was not eligible for the death penalty under North Carolina law. The events of October 13th began inside the Thompson family home. Thompson had armed himself with at least 2 firearms, a shotgun and a handgun, and had dressed in camouflage clothing. He entered the room of his 16-year-old brother James and shot him. He then stabbed James repeatedly. A handwritten note later recovered from Thompson's bedroom, in bearing his name and the date of the shooting, stated that he killed his brother because James would have interfered with what he planned to do next. Thompson then left the house. He moved through the Hedingham neighborhood on foot, firing at people he encountered. Nicole Connors, 52, was shot outside her home as she prepared to walk her dogs with a neighbor, Lynn Gardner, who was also shot and seriously injured, sustaining wounds that required hospitalization for approximately 3 months and resulted in permanent hearing loss. Off-duty Raleigh police officer Gabriel Torres, 29, was shot while en route to begin his shift. Mary Marshall, 34, was shot along the Neuse River Greenway Trail. Susan Carnatz, 49, a jogger, was also shot on or near the trail. On-duty officer Casey Clark was shot in the leg during the subsequent response. Thompson then fled into the surrounding woodland and residential area, and he was located hours later, approximately 6 miles from his home, sheltering in a shed. He had sustained a self-inflicted gunshot wound to the head and was transported to hospital. 5 people were dead. 2 others had been shot and injured. Investigators from the Raleigh Police Department and Wake County worked in parallel on the physical evidence from the multiple scenes and on the digital record accumulated from Thompson's devices and online activity in the months prior to the shooting. And the search history recovered from his electronic devices documented sustained engagement with content related to firearms, mass shootings, explosives, and bomb-making materials. Research spanning a period investigators characterized as months rather than days. The prosecution argued that the specificity and duration of that digital record, combined with the handwritten note, the camouflage clothing, and the sequential nature of the shooting, moving from target to target along a planned route, established premeditation of a scope that went well beyond an impulsive act. Thompson's father was separately investigated, and in 2024 pleaded guilty to the improper storage of the handgun authorities determined had been found on Thompson at the time of his arrest. He received a suspended sentence and probation. Thompson's trial in Wake County Superior Court was scheduled to begin on February 3, 2026. On January 21, 2026, fewer than 2 weeks before that date, he entered guilty pleas in open court to 5 counts of first-degree murder, 2 counts of attempted first-degree murder, 2 counts of assault with a deadly weapon with intent to kill, and 1 count of assault with a firearm on a law enforcement officer. His defense team stated that the decision to plead was made to spare victims' families the ordeal of a full trial. When the case proceeded directly to a sentencing hearing before Wake County Superior Court Judge Paul Ridgway, which lasted approximately 2 weeks, the prosecution presented the digital search history, the note, and testimony from an FBI behavioral profiler who addressed the indicators present in Thompson's pre-incident conduct. The defense argued that Thompson had been experiencing a dissociative episode at the time, potentially triggered by an acne medication called minocycline, and presented psychiatric and genetic testimony in support of the theory. Ridgway rejected the medical argument, citing the duration and specificity of the pre-incident planning as directly inconsistent with an episodic loss of awareness. On February 13, 2026, Judge Ridgway sentenced Austin David Thompson to 5 consecutive terms of life in prison without the possibility of parole, 1 for each murder conviction, plus an additional minimum of 157 months for the attempted murder and assault charges. In his remarks, Ridgway stated that the evidence of months of planning and the methodical nature of the attack established Thompson as the rare juvenile defendant whose conduct reflected irreparable corruption satisfying the standard established by the United States Supreme Court for imposing a life without parole sentence on a juvenile offender. Thompson's attorneys announced their intention to appeal. He was led from the courtroom in handcuffs without making a public statement. Number 10. Susan Louise Lawrence. Marion County Sheriff's Office dispatch logs for the evening of June 2, 2023, document 2 calls originating from the same residential address in Ocala, Florida, each within minutes of each other. The first, placed at approximately 9 p.m., reported a trespassing complaint involving juveniles outside the caller's door. Deputies were already en route to that address when the second call came in, reporting that a shot had been fired. Officers arrived to find a 35-year-old woman on the ground outside the front door with a single gunshot wound to the chest. The door through which the round had been fired was still locked. Susan Louise Lawrence was 58 years old at the time of the shooting and had resided in an apartment in the Ocala area of Marion County, Florida, for approximately 3 years. Her background included a documented history of significant personal difficulty. Testimony at her sentencing hearing from her sister established a childhood marked by physical and sexual abuse, and a mental health evaluation produced a diagnosis of post-traumatic stress disorder. She had no prior criminal record. It's within her immediate neighborhood, however, a pattern of conduct had accumulated over a prolonged period that was documented in law enforcement records. Since January 2021, Marion County Sheriff's deputies had responded to approximately 6 documented calls involving Lawrence and the family who lived across from her. Calls originating both from Lawrence and from others. Multiple witnesses in the neighborhood reported that Lawrence had directed racial slurs at the children who played in the grassy common area adjacent to her apartment, had waved firearms at them on prior occasions, and had thrown objects at them, including a roller skate that struck one of Owens's children. Ajiki Chantrell Owens, known to family and friends as AJ, was 35 years old and the mother of 4 children, aged between 3 and 12, and the central friction between Owens and Lawrence had persisted for the full duration of Lawrence's residency and centered on the use of the grassy area near both their homes by Owens's children. On the evening of June 2nd, an altercation had taken place in that area in which Lawrence reportedly swung an umbrella at Owens's children. Owens went to Lawrence's door to confront her about the incident. The door was a solid metal front door with no window or visibility panel. Lawrence, either from inside the apartment, called 911 and reported that juveniles were outside, and she felt threatened. That call ended when the dispatcher confirmed deputies were on their way. Owens was standing outside the closed and locked door with her 10-year-old son beside her. Evidence presented at trial documented that she was unarmed and had not attempted to force entry. Lawrence then retrieved her .380 caliber handgun from a bedroom, passing an additional interior door that separated her from the front entrance, returned to the front door, and fired a single round through it. The bullet struck Owens in the chest. She fell outside the door and was transported by ambulance to a local hospital, where she was pronounced dead. Her son was present at the moment of the shot. Marion County Sheriff Billy Woods declined to make an immediate arrest, publicly citing the need to evaluate the applicability of Florida's Stand Your Ground statute before proceeding. That position generated immediate and sustained public response. Civil rights attorney Benjamin Crump, retained by Owens's family, publicly called for Lawrence's arrest and characterized the shooting as an unconscionable act with no legal justification. Approximately 30 community members gathered outside the Marion County Judicial Center the following day. On June 6, 2023, 4 days after the shooting, Lawrence was arrested. At a press conference accompanying the arrest, Sheriff Woods stated directly that "stand your ground" did not apply in this circumstance, and that the shooting had not been legally justified. State Attorney William Gladson charged Lawrence with manslaughter with a firearm, a first-degree felony, along with culpable negligence, battery, and 2 counts of assault. A decision not to charge her with second-degree murder, each which carries a potential life sentence, drew criticism from Owens's family and advocates. Investigators noted that Lawrence had called 911, had been advised deputies were en route, and had positioned herself behind a locked door before retrieving the firearm and returning to the door to fire. Body cam footage from the responding officers, subsequently obtained through public records requests, documented the scene, Lawrence's conduct during the initial police contact, and in the interrogation that followed. Footage that became the foundation of a 2025 Netflix documentary on the case. The trial took place in Marion County Circuit Court in August 2024, before Circuit Judge Robert Hodges. The prosecution presented the timeline of the 2 911 calls, the physical evidence establishing that Owens had not breached the door, the testimony of neighbor witnesses regarding the prior pattern of conduct between Lawrence and the Owens household, and the forensic evidence from the door itself. The defense argued that Lawrence had genuinely feared for her life, that Owens had been striking the door with sufficient force to shake the walls, and that the stand your ground framework entitled Lawrence to respond without waiting for an intrusion to be completed. The 6-person Marion County jury deliberated for under 3 hours before returning a verdict of guilty on the manslaughter with a firearm charge. Judge Hodges remanded Lawrence without bond pending sentencing. On November 25, 2024, Judge Hodges sentenced Susan Louise Lawrence to 25 years in state prison, 5 years below the 30-year statutory maximum. In his remarks from the bench, Hodges stated that Lawrence had been behind a locked door, had already summoned law enforcement, had known they were on their way, and had voluntarily retrieved a firearm and placed herself in front of the door before firing. He concluded that the shooting had been driven by anger rather than fear, and that no objective basis for imminent danger had existed at the moment she pulled the trigger. Lawrence addressed the court before sentencing and offered a statement of regret to Owens's family. Her attorney indicated an appeal was under consideration. Owens's mother, Pamela Diaz, addressed the court and spoke outside the courthouse following the sentence. The case was the subject of the documentary The Perfect Neighbor, directed by Geeta Ganbir, which premiered at Sundance in 2025 and subsequently became available on Netflix. Lawrence is currently serving her sentence in the Florida State Prison System.